Do you wonder what Karen Reed's lawyers are doing right now? How they're spending their time? Well, in just a few minutes, I'll tell you. Here's what we're talking about today. The initial hard part of their efforts is over. They've prepared a complaint for damages listing all of the causes of action they could reasonably assert against everyone but the Massachusetts State Police. And once the time for amendment, once the time for notice expires, they'll file an amendment to the complaint that brings in the Massachusetts State Police. So, do these lawyers now just sit back and wait for the defense attorneys to react and weigh in with an answer or motions? Most likely not. Good lawyers know that cases are won in the law library, not always in the courtroom. Those lawyers are all gathering cases and exploring all the potential defenses that the defendants could mount. Let's take a look at paragraph 6 of Karen Reed's complaint. It builds on the prior paragraph where they say that Proctor told others that the cops who owned the house where John O'Keefe was found would not get into any trouble. Here's where it picks up in paragraph 6. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA. Now, these introductory paragraphs, which lay out the narrative of the case for the plaintiff, are all taken from facts established in the criminal trial transcript. In fact, I would be amazed if they didn't have page and line number from the trial transcript showing where all these things happened. The defense will have a hard time saying, well, that didn't happen. Instead, they'll have to come up with another way to defeat this kind of stuff. But the lawyers right now are looking to bulletproof these allegations, so they have to think to themselves, what will the defense say? And most likely they'll say, well, there was just no need to search the house because he wasn't found in the house. Of course, we all know this isn't right, and in fact, it's kind of moronic. We've seen tons of cop shows where they cordon off the entire block sometimes and go inch by inch, square by square, and go over everything everywhere. We've seen it on CSI. We've seen it on CSI Miami. We've seen it on Law and Order and similar shows. And we know that the forensics people should have been all over that property that morning. But us knowing it doesn't prove it. It needs evidence. To combat this, the plaintiffs will already have laid in an experienced criminal investigator, likely a retired investigator, probably someone from like the NYPD or LAPD or similar agency, someone familiar with murder cases, somebody familiar with forensics, somebody who's been the lead investigator in multiple homicides, and that expert is going to be willing to testify that this was an aberration and that everywhere on that property was a crime scene until proved otherwise. And so that part of a defense, well, we just didn't find him in the house, is not going to go anywhere. They'll be ready for that. Now let's look at the next sentence in the paragraph. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he'd been wearing that night, and without his left shoe. Again, all of this is going to be taken from the criminal trial transcript. So the defense has to say it wasn't obvious to Proctor that O'Keefe was without a coat because he had been in a warm car and he was on his way into a warm house when Karen allegedly hit him. They'll point the finger at Karen Reed. They know she's been acquitted, but they'll still point the finger at her. So Proctor will assert that he knew she counted on John O'Keefe dying in the snow. That's what the defense will argue. To combat this, the criminal investigator will talk about confirmation bias and how Proctor had found a suspect and built the case around the suspect and not built the case around the facts. And he did that because he wanted to help out his friends. You see what's happening here. These lawyers are not going to be satisfied with merely waiting to respond to motions. They're busy building a suit of armor around their factual basis and supporting it with expert testimony. But of course, that's not all they're doing. They're also preparing for the motions to dismiss that are sure to be coming from the defendants. Normally, we think of a complaint being filed by the plaintiff and an answer to the complaint, which essentially denies everything, being filed by the defense. But the law allows an intermediate first step for defenders, and that is the filing of a motion to dismiss. And often the answer isn't due until after the motion to dismiss is ruled upon. There are dozens of reasons why a case might be dismissed, but the two most common are lack of jurisdiction and failure to state a claim of relief for which relief can be granted. I don't believe they'll attack jurisdiction. I think what they'll do is they'll say that the 1983 claims fail to state a claim that would allow relief to be granted. And here's how they will do that. First, they'll argue that the grand jury found probable cause. Of course, we know that the grand jury was deprived of a full recitation of the evidence and that the investigative work was terribly flawed and tainted with bias. But they'll claim that the jury indictment essentially immunizes their conduct. Like I said, I'll deal with this in a second. If that doesn't work, they'll fall back on qualified immunity. Qualified immunity is a doctrine that says an officer can't be held liable unless he violated a clearly established constitutional right that a reasonable police officer would have known. Now, arresting a person without probable cause is certainly a well known and well understood violation of the Fourth Amendment. The fallback position here is that even if it was a mistake, even if there was a minor overlooking of items in the investigation, imagine, and officers acted reasonable under the circumstances, that's what they're going to say. They're going to say, you know, the sun was in my eyes. I didn't know the gun was loaded, you know, things like that, ridiculous excuses that, and they'll say, well, I was acting reasonably. But of course, because they never went into the house for over a week and they had already made up their mind to pin it on the girl, they should be held to answer for a gross violation of the Fourth Amendment. But many cases end at the qualified immunity argument. However, most of those cases do not have these kinds of facts. If you were to go through the case law in federal courts on 1983 actions, you'd probably find about 80% of them dismissed on qualified immunity and a success rate of only about 30% on the cases not dismissed outright. That's because a majority of these cases are filed under the Eighth Amendment, where prisoners are claiming cruel and unusual punishment because they can't get chunky peanut butter instead, and they get this creamy Jif peanut butter instead, and sometimes stale bread. That seems to be a lot of what the 1983 cases that are dismissed are all about. It's prisoners engaging in recreational litigation. But the Supreme Court seems fond of meritorious 42 U.S.C. Section 1983 cases. And Shiverini versus the City of Napoleon, Ohio, ought to give the defendants pause here. It shows that even where there was probable cause for one charge, in Karen Reed's case, the DUI, the failure of probable cause for the others creates liability. In that case, police officers charged Shiverini, a jewelry store owner, with 3 crimes: receiving stolen property, a misdemeanor; dealing in precious metals without a license, also a misdemeanor; and money laundering, a felony. After obtaining a warrant, the police arrested Shiverini and detained him for 3 days, but county prosecutors later dropped the case. Shiverini, believing his arrest and detention were unjustified, then sued the officers, alleging what is known as a Fourth Amendment malicious prosecution claim under 42 United States Code Section 1983. To prevail on that claim, he had to show that the officers brought criminal charges against him without probable cause, leading to an unreasonable seizure of his person. The district court, however, granted summary judgment to the officers, and the Court of Appeals for the Sixth Circuit affirmed. The Court of Appeals held that Chiavarini's prosecution was supported by probable cause. In holding this, the court did not address whether the officers had probable cause to bring the money laundering charge. In the Sixth Circuit's view, there was clearly probable cause to charge Chiaverini with two misdemeanors, and so long as one charge was supported by probable cause, it thought a malicious prosecution claim based on any other charge must fail. Supreme Court said, not so fast. The presence of a probable cause for one charge in a criminal proceeding does not categorically defeat a Fourth Amendment malicious prosecution claim relating to another baseless charge. The parties and the United States as amicus curiae all agreed with that conclusion, and it follows from both Fourth Amendment and traditional common law practice. So in Karen Reed's case, they brought three charges: murder, leaving the scene of an injury accident, and DUI. She was convicted of the DUI. Under Chiaverini, that conviction does not immunize the other unlawful arrests. So you can bet that the lawyers are putting that case in their bag of tricks to argue before the trial court. Now, we mentioned earlier about the indictment. So that's one of the fallback positions for him here. And ordinarily, an indictment returned by a legally constituted and unbiased grand jury is prima facie evidence of probable cause. That's Cayley versus the United States, 571 U.S. 320, 2014 case, and Gerstein versus Pugh, 420 U.S. 103, a 1975 case. Under normal circumstances, that indictment breaks the chain of causation between the officer's investigation and the judicial process. But does that mean the cops can lie to a grand jury or omit mountains of exculpatory evidence and get away with an unlawful detention? No. There's an exception. The indictment shield does not apply if officers misled the grand jury. The presumption of probable cause collapses when law enforcement procured the indictment through deception, material omissions, or fabrication of evidence. In such cases, courts treat the indictment as invalid for probable cause purposes because the grand jury's decision was not independent. It was tainted. This flows from the fundamental rule established in Franks versus Delaware, which is a 1978 case, 438 U.S. 154, where they held that fabricated or knowingly false statements used to secure a warrant undermine probable cause. Courts extended this logic to grand jury indictments in Section 1983 suits. Manuel versus City of Joliet, 580 U.S. 357, a 2017 case. There, the Supreme Court clarified that pretrial detention supported by fabricated evidence violates the Fourth Amendment and is actionable under 1983 even after the start of legal process. Thus, if the indictment is based on fabricated, manipulated, or withheld evidence, then the resulting detention is unsupported by probable cause, even though a grand jury issued an indictment. Well, how do plaintiffs prove that? To overcome the indictment's usual presumption, the plaintiff has to show intentional or reckless misrepresentations. Police or investigators knowingly made false statements or acted with reckless disregard for the truth. I think we'll have that in spades in the Karen Reed case. Material omissions. If they left out exculpatory facts that would have changed the grand jury's decision, and there are multiple instances of that, including the fact that the very medical examiner said he wasn't hit by a car. I mean, that should have been all the jury needed to hear to know that this wouldn't be a good case. Those kinds of things undermine the indictment shield. And also fabrication of evidence, creating evidence the officer knew was false, either in doctored reports, pressured witnesses, false forensic claims. For example, a shattered taillight that magically appeared after transporting a vehicle to the police garage, when it was merely cracked at the site when it was picked up and shattered at the site when it was eventually found. That seems to indicate that they had intentionally manufactured false evidence. Then there has to be a causal connection, but for standard, the indictment would not have issued but for this deception. Once the plaintiff shows these, federal courts treat the indictment as a nullity for purposes of probable cause. You can bet that Karen Reed's lawyers have read and probably memorized Jones versus City of Boston, a 2816 case in the First Circuit where false statements and forensic manipulation led to an indictment, and that indictment did not shield the police. So that's, in my opinion, what's going on in the Karen Reed camp right now. They are getting ready to try and defeat the first motions to dismiss that are going to be filed. And I think they have a pretty good chance because they're very smart lawyers, they're very good lawyers, and I look forward to being able to report on that in the upcoming weeks. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee, anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.